February the 3rd, February the 2nd, actually. Little Nancy Sinatra getting us started there. That song never gets old. There was a major landmark decision that was rendered on Friday by the Ontario, gotta get the name of the damn province right, Court of Appeal. In terms of medical marijuana, it was regarding a case of a guy living in the province who has several illnesses but can't get his doctor to give him a prescription or approve his request for medical cannabis. And the judges in the case decided that it's still necessary for folks who need this medical cannabis to get approval from their doctors. To a certain extent, it's a victory for those who want to regulate this sort of business of medical marijuana, but it is a disappointment to medical marijuana advocates and for those who lobby on behalf of people, such as those living with HIV and AIDS, who use medical marijuana to deal with their illnesses. We've got one of those advocates on the line right now, Lynne, Belle-Isle, who is the program consultant for the Canadian AIDS Society. Lynne, thanks for coming on my show today.
You're very welcome, Todd. Good morning, or good afternoon.
Yeah, you are in Vancouver, correct?
Actually, in Victoria.
Victoria. Yes. Beautiful Victoria. Okay, listen, tell me what you think this court ruling, I mean, if only for the province of Ontario at this point, but, precedent is being set here, will mean for HIV and AIDS patients and other folks who use medical marijuana, perhaps nationwide.
Exactly, and that really is our role at the Canadian AIDS Society, is to look at these regulations and these court decisions and make sense of them and see what the impact of them are on people living with HIV/AIDS in our case, and other conditions across Canada, who may want to use cannabis to alleviate some of their symptoms. And I say cannabis because that's the name of the plant, right?
Absolutely.
We could say marijuana if you like. So basically, just to take you back a little bit, back in 2000, there was a case called R versus Parker, where a man, Terry Parker, won the constitutional right to access cannabis for medical purposes. And at that time, the judge had found that the government has to make provisions to allow people to be authorized to possess cannabis for medical purposes. Otherwise, the prohibition on cannabis is invalid under the Controlled Drugs and Substances Act. So back in 2001, the marijuana medical access regulations came into effect. So people could obtain an authorization to possess cannabis for medical purposes. Now, yesterday's decision, there was a clarification about that. The judges were very clear in saying that it's not a free-for-all. It's not because you have a serious illness or symptoms that you automatically have a constitutional right to cannabis for medical purposes. They say that the medical purpose has to clearly be demonstrated. And this is where the clincher is in this whole situation. And this has been a challenge for people looking for this medical declaration from a physician. So right now, under the regulations, for a person to get authorized to possess marijuana for medical purposes, they have to apply to the program and they have to get a physician to sign their application form. And the application contains a medical declaration that the doctor signs. And the judges in this Mernagh decision yesterday said that that is basically the requirement that confirms the medical purpose. But the difficulty in Matt Mernagh's case, and in many people's cases, is that they have a very difficult time finding a physician to sign that medical declaration.
So that's the issue, right?
That's the big clincher.
Getting doctors who will sign it.
Exactly. So we're kind of caught in this catch-22, right? The physicians, they basically have been forced into this role, right? They've been reluctant from the beginning because you can imagine, the physicians are not used to dealing, first of all, with herbal medications or medicines, like cannabis is a plant. And we're not talking about, there are pharmaceutical options like synthetic THC, but we're talking about the plant itself. So they're not used to dealing with that. It's a controlled substance. It's the most widely used recreational substance in the world. So they're a bit reluctant. They don't have a lot of information about cannabis as a therapeutic agent.
Let me ask you this, Lynne. Right now, if you can't find a doctor who'll do it or whatever, do patients basically resort to breaking the law to get a hold of it?
Well, many do because they feel they have no choice, and many don't and then go without the benefits, right? It's a personal choice. And that's the concern that we have. We don't want people, in our case, people living with HIV/AIDS, to have to break the law to be able to alleviate symptoms that they can benefit from the use of marijuana for.
What is your organization, the Canadian AIDS Society? I mean, what are you guys planning to do now after this decision?
Well, we've been working all along since the very onset, development of the regulations. We've been involved in providing input. There used to be, back in the day when the regulations first came out, Health Canada had set up a stakeholder advisory committee on which we sat, and we basically, on a continuous basis, I'm always contacting people living with HIV, and now people with other illnesses too, because there are a few people that are advocating on their behalf, and just getting a sense for them. How are these regulations working? What are the barriers you are experiencing? And my job is to bring that back to the government and give input. Okay, so these regulations are working in this area, but in this area there's still things that need to be resolved. So that's basically what we do. So there was a study that I did back in 2005 that has been used in a few of these court cases where we did report on the barriers to access. And so we're continuing to be involved in that. There's a research meeting coming up in Vancouver in a couple of weeks that I will attend, where a bunch of us kind of researching this area are getting together to set research priorities.
But Lynne, there's going to be people out there as well who say, well, what's wrong with allowing a medical doctor to sort of, be the one to decide? Because otherwise, it just becomes sort of a free-for-all. So maybe it shouldn't be too easy. I mean, what do you say to those folks?
Yeah, and it's not a matter of whether it's easy or not. And I agree. I mean, we are in a society that embraces a medical model, and this is, a controlled substance, and we have to have regulations in place. We don't disagree with that. The problem is that physicians are feeling that they don't have enough information. Meanwhile, it's not all physicians that feel this way. I mean, you have in Montreal a world-famous expert, Dr. Mark Ware, who's a pain specialist and happens to be a cannabis researcher in Canada, and he feels that it's just because doctors are just not aware of the existing scientific evidence. And he has taken it upon himself to advocate to doctors, and he's even created a continuing medical education unit so that physicians can go and get training specifically on the medical use of marijuana. He claims that there is enough evidence to support medical benefits of cannabis, and so basically it's just a matter of doctors being aware of it. So there's that, and of course you can imagine these things. It's kind of a paradigm shift for physicians, right, to kind of embrace cannabis as a medicine. So these take a lot of time. And in the Mernagh case, it was made clear that, yes, since the beginning of the regulations, there are more physicians that are kind of signing applications as time goes by. It takes a long time.
Absolutely.
And we keep coming back to the poor patient trying to find doctors.
Squished,
They sometimes they luck out and they find one that happens to be well-informed and has done maybe a bit more research in this area. And I have to say that when the regulations were enacted back in 2001, Health Canada had put together an expert advisory panel of physicians and researchers to look at the evidence and to determine which conditions and which symptoms do we know there are medical benefits for. And in the regulations, there is a Schedule 1, it's a table that summarizes a list of illnesses and symptoms for which we know there is adequate scientific evidence to support the medical use of cannabis. So there is more information out there, but physicians are a little bit scared. The professional bodies have been very vocal about their reluctance to support this. They've also been forced into this role, right?
Absolutely. We're going to have to leave it there, Lynne, because I'm running out of time. But I want to thank you for sharing your viewpoints here on the show.
No problem.
And all the best to you out in Victoria.
Thank you very much.
Lynne Belle-Isle is with the Canadian AIDS Society talking to us about this court decision yesterday on the use of medical marijuana. A quick break here on Viewpoints. We're going to check in with all the day's top headlines right now in the CJAD News Center. Luciano Papilla